Hey everybody, Todd Vandermide here for another edition of Freedom Steel. So today the Hemani decision came down. Getting high is not a problem for the High Court. More after the intro. Hey everybody, Todd Vandermide, former NRA contract lobbyist, gun law guru, and the gun Santa, as described by some. So it's been a while, but we've got something to talk about today. What we've got is the Hemani decision came down from the Supreme Court. This was a case to where an individual was charged solely with the violation of being in possession of a firearm while being a user of marijuana. And while this is not always the best fact pattern for us, the neat thing about this case was it was the only charge. He was investigated for things associated with terrorism, and my friend Costas Moros over at the Second Amendment Foundation did an amici brief on this and urged the court not to look into things that weren't charged as they tried to gussy up or dress up this case, much like the Biden administration had done with the Rahimi case. But there are some interesting things about this case, and I'm hoping that Mark Smith from Four Boxes Diner, Bill Kirk from Washington Gun Law, and my good friend Costas Moros all pick up, and I want to hear some of their opinions on a couple of things, but trying to get this out and be out there so I'm not influenced by anything else. But first off, it's a 9-0 opinion. Woohoo! Even the liberals said that this was too broad, that this blanket prohibition just sat there and violated the Second Amendment. Great. The opinion is written by Justice Gorsuch. I see this as being important because if you ever listen to him during the oral arguments, he's very methodical. He doesn't get flustered, doesn't fly off the handle like, Justice Jackson doesn't lose his shit. He's just, unflappable. And so I think parts of this are really important because he spends a fair amount of time deconstructing what the government was arguing that the drunkard laws and surety laws were good analogies to uphold this part where people who used illicit narcotics one way or another would be prohibited. And I think he really focused on that you could get 15 years in jail for this blanket prohibition without anything that likened to the dangerousness of the individual or their propensity for violence or anything like that. That it was just pure out prohibitive factor. Now, they go on to say that it doesn't say that somebody who's addicted and could be a menace can't be prohibited from owning firearms, but the way they're doing this as is right now, unconstitutional. I think the way he goes about this for the analogies, he gets into the how and why a lot as to why the three things about drunkards that the government proffered don't apply here. And I think one of the interesting things is what we can take away from this. I think we can take away that this was Justice Gorsuch deconstructing all the arguments that use the black codes for justifying bans on firearms. That it's like, no, the how and the why are not the same. The mechanisms aren't the same. And I think this was aimed at deconstructing the use of those types of analogies in other arguments that governmental entities are making. I think he also did this to knock out the arguments where government uses the Bowie knife bans in order to justify gun bans, and that the same how, why, and all that. And I think he specifically spent as much time as he did going into some of this stuff simply because I think they wanted to put a marker down and they're trying to give some direction and say, yeah, we're not going to let you just analogize out and stretch this thing like a rubber band. No, that's not going to happen. They left untouched, whether it's 1791 or 1868. They, in footnote 3, sit there and say, hey, nope, we're not deciding that today, which is about par. They're punting. They're doing some narrow things here. One of the other things is we've got footnote 6, which I think is interesting because in here, they talk about due process, and I think that's very important. Under footnote 6, it says certain other provisions of subsection 922, such as subsections G1, disarming convicted felons, and G4, disarming any person adjudicated as mental defective or committed to a mental institution, involve some manner of pre-deprivation process before an individual's Second Amendment rights are lost. For that reason, they differ from subsection G3, and nothing in our opinion should be taken to cast doubt on them. So here they are acknowledging that in G3, here this part about the person who uses illegal substances, that there's a due process for these other things. And I think hopefully this footnote 6 will be used for us on our side, much like the other side tries to use footnote number 9 from Bruin about, the constitutionality of certain licensing laws. And to go on, none of that holds true for 922 G3. On the government's account, the statute automatically divests an individual of his constitutional right to bear arms the moment he becomes an unlawful user and until he ends his drug use, all without any pre-deprivation process. To be sure, and as the government highlights, an unlawful user who violates this ban is entitled to full dress criminal trial before he can be imprisoned or permanently disarmed. Brief for the United States, page 26, whatever. But be that as it may, 922 G3 offers an unlawful user no pre-deprivation process before his temporary disarmament. The very burden the government says is akin to the burden vagrancy, civil commitment, and surety laws imposed on habitual drunkards. I think this is huge. I think this gives us some standing to go after the things like Illinois' clear and present danger. It gives us some standing to go after red flag laws and the like. Because of that, I think there's some nuggets in there. There are some treats sprinkled throughout this decision. Now, Justice Jackson, our favorite DEI, malpractice of the bar exam, she and Sotomayor agree with the outcome, but they lament they can't use means and scrutiny, and they want to go back to the good old days where we could hardly ever win a case unless it was so egregious, because they could just justify away our rights by saying the government had some sort of compelling interest. And so they're not getting what they want, but the fact this is 9-0 says a lot. Now, what's coming next? Don't know. Could they be using this to GVR the 5 hardware cases and say, see, Hemani, try again? That would put us back and stop it. But one of the other things that's in here is they talk about they like developed cases, which bodes to either the New Jersey semi-auto ban pending out of the 3rd District or our case, Barnett et al. In the 7th District. So we'll have to wait and see. But as I said, it's kind of funny that the High Court says getting high is not an impediment necessarily to your Second Amendment rights. And I think this may be the first decision where they actually bring up the use of gummies. Justice Gorsuch seems to be very much in tune on these things. But that's it. That's the long and the short of everything here. So As always, please like, subscribe, copy, paste, share this link around. I'm really going to be interested to see what some of the other commentators have to say about what I think some of the nuggets in this case is. But with that, as always, guys, stay safe. Frag out.